let us start. First of all, we read quotation. कभी हार ना मानने की आदत, कभी हार ना मानने की आदत ही एक दिन बड़ी जीत दिलाती है। कभी हार ना मानने की आदत ही एक दिन बड़ी जीत दिलाती है। It means if a person believes himself and continuously work hard, never get defeat. One day he shall succeed. Okay, let us start. Question number 1. When oral admission as to content of document are relevant, when oral admission as to content of document are relevant, the party proposing to prove them shows that he is entitled to give secondary evidence of the content of such document. If the person making admission as to content of a document, oral admission, not only admission, oral admission. If oral admission is produced as an evidence to the content of document, such oral admission shall be relevant as an evidence when the party is entitled to produce secondary evidence. It means if any term and condition mentioned in the section 65 of Indian Evidence Act, if any term and condition is present, then the person making admission, oral admission, shall be produced as an evidence in the court. Okay, so the correct answer of the question shall be A. The genuineness of a document produced is not in question. All these are wrong option. Next. Which section of Indian Evidence Act has been amended in 2000 for admission of electronic records? You see that Section 20A has been amended. Section 20A has been amended in 2000 for admission of electronic records. So the correct answer A. assertion, oral admission of content of electronic record are always relevant. Oral admission of content of electronic record are always relevant. Reason: statement contained in electronic form is an admission. Yes, it is defined in the section 17. So reason are true. Reason is true, but oral admission of contents of electronic record are always relevant. No. 22A. Section 22A says that such type of oral admission of electronic content, electronic records, when the condition mentioned in the section 65, any condition is present, then oral admission shall be produced as an evidence to the content of electronic record. So both A and R, so this is wrong, false. Is the correct explanation? No. Both A and R true? No. It is also. So above these three options are incorrect, but D is correct answer. Why? Because according to section 17, reason is true, but according to section 22A, the statement is not correct. A is incorrect. Assertion is wrong. So D option is correct answer. Next question. Question number 3 I have taught you. Question number 4. Which of the following section of Indian Evidence Act does not deal with the criminal matters? Yes, section 23. If you study section 23 of Indian Evidence Act, in civil matter it is written. So section 23 is not applicable in criminal matter. It is relating to civil matter. It is pronouns are mentioned in the section 23 of Indian Evidence Act. So the correct answer of the question is A. Okay. Next. Which section of the Indian Evidence Act deals only with civil matters? Yes. Repeat the question. Section, this is the correct answer, section 23. Section 23. Okay. Question number 5. Section 23 deals with civil matter. Next question. When a person makes an admission upon a condition that evidence of it shall not be given, it cannot be proved against him. This is laid down in section 23. It is mentioned, it is laid down in the section 23. Because if any admission is made upon a condition that evidence of it shall not be given as an evidence, section 23 says it. So the correct answer of the question C. Question number 7. Communication made without prejudice are protected in the section 23. Without prejudice. In general case, if any admission is given in civil case upon this condition that it should not be produced, it shall not be produced as an evidence. If any admission is made, such admission shall not be produced as an evidence. So the correct answer C. Okay. Next. From the following, which is an exception to section 23 of Indian Evidence Act? Which is an exception? 126 is the exception of the section 23, because here barrister, pleader, they are not bound in special cases to disclose. So A is the correct answer of the question number 8. Next question. Nothing in section 23 of the Indian Evidence Act 1872 shall be taken to exempt any barrister, pleader, attorney, vakil from giving evidence of any matter of which he may be compelled to give. Evidence is provided in the Evidence Act 126. This is the exception to the section 23. So the correct answer of the question is 126. Okay. Next question. A confession is an admission made by any time by a person charged with crime stating or suggesting the inference that he committed that crime. If the person who has been charged stated that he has committed the offense, it means he confessed his offense. He has confessed his offense, it means, because whatever charge was imposed upon him, he accepted, he admitted. So when he admitted the charge, it means he confessed the charge. So the correct answer, who has given this definition of confession? It was given by Stephen. It was given by Stephen. Such definition was given by Stephen. But Atkin defined the confession, Pakla Narayan Swami versus Emperor. He defines the confession when a person admits his offense expressly and his confession or his admission is not self-incriminatory nature, then such admission shall be called confession. Here the inference, not direct, it is indirect. So according to Atkin, it is not a confession. But Sir Stephen has accepted this definition of confession. So the answer of the question A is the correct answer. Next question. Which of the following statements comes under the term confession? Which statement is known as a confession? When accused admits the commission of crime committed by his relative. Which of the following statement comes under the term confession? It means which one of the statement is regarded as a confession? The first one, when accused admits the commission of crime committed by his relative. No. When accused admits the commission of a crime by his own or admits facts which constitute the crime. Yes. It is said in the case of Pakla Narayan Swamy versus Emperor 1939, Lord Atkins says that. Lord Atkins said that statement. So the statement shall be called as a confession. Here option B is the correct answer of the question. Option B is the correct answer of the question. Next question. In Evidence Act, confession is defined under. In Evidence Act, confession is defined under section 1920. No. It is not defined in the section. Confession is defined by Lord Atkins in the case of Pakla Narayan Swamy versus Emperor. So none of these. This is the correct answer. A confession caused by an inducement, threat, promise is irrelevant under section 24. Under section 24. So it is the correct answer of the question. Section 24 says that if any confession is given under inducement, threat, promise, such confession shall not be relevant. So correct answer of question 13 is B. Next. A confession which is firstly be accused but after some time goes back and denies it is called retracted confession. He confessed his offense firstly and after some time he goes back. Such confession is called retracted confession. Here A is, this is incorrect, it is also incorrect. C is the correct answer. Question number 15. A confession is inadmissible if it is made by the accused. If it is made by the accused to a magistrate while he is in the custody of police officer. No, it is correct. Correct means incorrect here. To a doctor while he is in the custody of a police officer. According to section 25, before police officer, If any confession is made, that confession shall be irrelevant. Whereas in the section 26 of Indian Evidence Act says that if any confession is made in the custody of police officer, such confession is also irrelevant. So, if any confession is made to a doctor while he is in the custody of police officer, shall be relevant. To his friend while he is not in the custody of a police officer, to a spiritual advisor. No. B is correct answer. Any statement, any confession if made before police officer or in the custody of police officer shall be always irrelevant. Okay? But if before the magistrate, though the accused was in the custody of police officer, but the accused confessed his offense before the magistrate, such confession shall be regarded relevant. Okay? But if he confess his offense, before doctor but in the custody of a police officer, such confession shall be irrelevant. Okay? So the correct answer of the question B. Inadmissible. A confession is admissible if it is made by the accused to a police officer, no. A doctor whilst he is in the custody of, no. His friend whilst he is in the custody of police, no. A spiritual advisor under the inducement for the good of this soul. Because here is no custody, no police officer. So the correct answer of the question is D. It shall be admissible. Extrajudicial confession means a confession made before judicial magistrate, no. Before doctor, before friend, both before doctor and before friend. Because B and C the both, and option D including the both. So D option is the correct answer of the question. Next, extrajudicial confession means a confession made before the magistrate in the court, no. To the police officer, no. To the doctor. This is the correct answer. Because doctor is neither a magistrate, nor a person, nor a police officer. So if any admission is made before doctor, may be admissible, and it is also known as extrajudicial confession. But if the police officer is present at that time when the person confesses his offense, such confession shall not be admissible. Here the question is, extrajudicial confession means a confession made to the doctor. If any confession is made before the magistrate in the court, such confession shall be called judicial. But if any confession is made out of the court, not before the magistrate, such confession shall be called extrajudicial confession. Here doctor is not a code. So the correct answer is C of the question. Next question. Which one of the following is a leading case on confession to person in authority? Authority. Ramesh Chandra Mehta versus is no West Bengal. Pyare Lal Bhargav versus state of Rajasthan. This is the correct answer. Yes. In this case, if any confession is made before authority, such confession shall not be admissible. If authority induces threat, then such confession that was made before the authority shall not be admissible as an evidence. Okay, so the correct answer of the question shall be B. B is the correct answer. Next question. A rustic woman. Rustic women. In apprehension of assault and maltreatment. Maltreatment. Makes a confession for murder. Here a rustic woman, the word rustic. In apprehension, it is also of assault and maltreatment. It means she was afraid of. She was in threat, in danger. She was in danger. And then murder. Mother-in-law at the village panchayat. Whether this confession is admissible or not. Because the woman was rustic and she was afraid of, and so she was afraid of being assault, or maltreatment to her. So she made a confession before a panchayat. It means if such confession is made before the panchayat, actually this type of confession shall be regarded under threat, under inducement, under apprehension. So it shall not be admissible. It shall not be admissible as extrajudicial confession. Inadmissible due to involuntariness. Yes, it is correct. Because inadmissible. Why? She does not make a confession. Her confession was not made voluntarily. She was under inducement. She was under threat. So her confession was not voluntarily, and in this way her confession shall be inadmissible. Her confession shall be inadmissible. The correct answer of the question shall be B. B is the correct answer. Okay. Inadmissible due to involuntariness. So the B is the correct answer, and other A, C, or D is not correct. Okay. These options are not correct. Only B is correct answer. So that's all. Okay, thank you. That's all.